Hey everyone, today we'll discuss the law of knowing receipt. If you ever wondered what happens when someone receives assets that were transferred in breach of trust or fiduciary duty and whether they can be held liable, this is the video for you. We'll break down what knowing receipt is and the legal requirements. First things first, what exactly is knowing receipt? In simple terms, it's a form of equitable liability where a person receives trust property or assets that were misappropriated or transferred in breach of fiduciary duty. To be held liable, the recipient must have knowledge of the breach and must have received the assets for their own benefit. In these cases, the focus isn't just on the act of receiving the property, it's also about the recipient's mental state and whether they knew or should have known that the assets they received were tainted. Now let's discuss the three essential legal elements of knowing receipt under Singapore law. First, there must be a disposal of assets in breach of fiduciary duty or trust. This means that the assets were wrongfully transferred by someone who was supposed to be acting in good faith, like a trustee or a director. Number two, the recipient must have received the assets for their own benefit. Simply acting as a conduit or just briefly holding onto the property doesn't typically qualify. Finally, the most critical element, the recipient must have knowledge of the breach. This can be tricky because knowledge can include actual knowledge, willful blindness, or constructive knowledge, where the recipient ought to have known something was wrong. At the moment, there are three competing theories to explain liability for knowing receipt of trust property. The first theory is that knowing receipt is premised on the principle of unjust enrichment, and hence liability is strict upon proof of receipt of trust property. It would be confined to restoring an unjust gain. The second theory is that knowing receipt is premised on the concept of unconscionability. This is the theory favoured by the Singapore courts. The relevant test was that laid down by Lord Justice Noose in Bank of Credit and Commerce International and Akindale, who said that the recipient's state of knowledge must be such as to make it unconscionable for him to retain the benefit of the receipt. This position was accepted by the Singapore High Court in George Raymond and Ho Chi Kwong. The salient points on knowing receipt are as follows. Number one, the degree of knowledge required to impose liability will necessarily vary from transaction to transaction. In situations where there is no settled practice of making routine inquiries and prompt resolution of the transaction is required, clear evidence of the degree of knowledge and fault must be demonstrated. Third point, unconscionability does not mean actual knowledge. The test for unconscionability is a flexible and factual-based inquiry. Fourth point, in the absence of actual knowledge, a defendant may be found liable for knowing receipt if there are circumstances that are so unusual or so contrary to be accepted commercial practice that it would be unconscionable to allow the defendant to retain the benefit of the receipt. Fifth point, constructive notice in the context of a knowing receipt should be understood as the doctrine of a constructive notice as developed in transactions in real estate. However, the court should not be precluded from considering the objective circumstances and peculiar practices, if any, of each type of commercial transaction, bearing in mind the need for expediency and certainty in commerce when assessing liability for knowing receipt. This means you don't always need smoking gun evidence that the recipient knew about the breach. Instead, courts will look at all the circumstances to determine if the recipient should have known that something was off. Suppose a director of a company misappropriates a company's funds and transfers them to their relative's personal bank account. If the relative knew or should have known that the funds were transferred in breach of fiduciary duty, they could be held liable for knowing receipt. In this case, if the relative knew that the director was not supposed to touch the funds, or if there were clear red flags, they could face legal consequences. Another example, imagine a third party receiving trust property as part of a transaction. If the third party is aware that the property comes from a trust and that it was transferred without proper authorization, they could also be liable for knowing receipt. So are there any defenses against a claim of knowing receipt? One defense is lack of knowledge. If the recipient can prove that they genuinely had no idea of the breach and that they were not reckless or willfully blind, they may avoid liability. To sum up, knowing receipt is a crucial doctrine in equity that ensures people can't simply hold onto assets that were misappropriated in breach of trust. The courts will look at what the recipient knew or should have known and whether they personally benefited from the asset transfer. If you ever find yourself on the receiving end of assets that you're unsure about, it's important to ask questions and act responsibly. Ignorance is not always bliss in the eyes of the law. Thank you for watching. Don't forget to like this video, share, subscribe to the channel so you don't miss future updates.